Welcome. My name is Andre Mejer, and today we're going to be talking about the UVisa. It's a victim of violent crime. We're going to talk about what is it, what are the requirements for it, what benefits do you get for it, and what are the steps from beginning to end. So thank you for joining us. For those of you that don't know me, I'm an author, speaker, and immigration attorney. I came to the United States as a child not speaking English. I moved to Israel as an adult not speaking Hebrew. I lived 2 times in Chile, 2 times in Israel, 2 times in the US. And my journey, like most of yours, was not simple. I was illegally in this country for almost 10 years. My family and I were a victim of fraud. I would be a dreamer, but for the fact that the law changed and gave me my ability to get a green card, and today I'm a U.S. citizen. And that's why I'm here to help you. So today, we're going to talk about UVisa. So first of all, what is the UVisa? UVisa is for a victim of a violent crime. The idea behind it is that generally immigrants are afraid to speak to law enforcement. They think, well, I was a victim of a crime, but I'm here illegally. So if I call the police, I might get arrested, I might get detained, I might get deported. So what UVisa does is to help. UVisa helps, and hopefully that's not a reporter. It's been one of those weeks. So UVisa protects the immigrant from being put into removal proceedings. Not only that, it is an avenue to get work authorization, to get legal status in the United States, and ultimately to get a green card and become a U.S. citizen. And with the changes that happened just a couple of weeks ago, you will now be getting work authorization sooner than ever before. So let's get right down to it. What are the requirements? Well, first of all, you need to be a victim of a qualifying crime. Now, there are 23 different crimes, and these crimes have to have occurred in the U.S. or have violated U.S. law. Now, most crimes are committed under state law. So we have to evaluate what happened, who was charged, so what was investigated, who was charged, and what was the outcome to determine, is there a qualifying federal law? And there are 23 of them. The most common is domestic violence, assault, and robbery. There are many others, but those are the 3 most common. So victim of a qualifying crime. Second, need to have you, the immigrant victim needs to have information about the criminal activity. 3, you need to be helpful to an investigation or to the tribunal. That means you spoke to normally the police. It doesn't have to be the police. It can be any law enforcement agency that has investigatory authority. So things like Division of Civil Rights or Division of Child Services. Those are agencies that have investigatory authority, but generally it is the police. So you have to report it to the police, which means there's a police report. Then the matter goes to the prosecutor's office. Prosecutor decides to prosecute the crime, and they will reach out to you for your assistance. That might mean make an affidavit, give a statement, go to court, give testimony. You need to comply with what they ask you to do. So, victim of qualifying crime, have information about the crime. Usually means you reported it. You assist in the investigation or in the prosecution. Now, when I say investigation, what does that mean? Well, maybe you report a crime, but no one gets arrested. Maybe they can't find the person that committed the crime against you. Or maybe they were found, they were arrested, they were released, and then were deported, or they disappeared. Point is, you did your part, but the individual has not been apprehended or hasn't appeared in court for reasons outside of your control. That's why there's a difference between have information and helpful. in the investigation or in the prosecution. 4, you suffered severe emotional or physical abuse due to the criminal activity. Now, if it was an assault and you have a bloody nose and a broken nose, or some other, you were attacked by a bat, or you were stabbed by a knife, you wind up in the hospital. Now, those are all examples of serious physical abuse, but not every violent crime results in physical abuse. So, for example, let's assume someone robs you, and in that doing, they threaten you with a knife. Now, maybe they swing it at you, maybe they make you think that they're going to kill you, but at the end of the day, they didn't actually hit you. They just used it. Well, that's a violent crime, but there wasn't a physical component to it other than your belief, your apprehension that you might have been. Well, that could be an emotional issue, in which case just getting medical records isn't enough, because you might not have gotten to a doctor. You might not have spoken to you might not have gone to the hospital. So you would need to speak to a psychologist or a therapist or a psychologist to evaluate and show the degree of harm you suffered emotionally and that it was related to your experience. And you need to be admissible to the United States. That means you're a good moral person. You haven't done something that would disqualify you. If you're a victim of a simple assault, but you just got out of jail serving 5 years for having put someone in a hospital in a coma, you know what? You're not likely to win or to get approved in that context. So they look at the totality of the circumstances. What disqualifies you, and how did you help the government, and figure out, hey, do you deserve to get this? Now, one of the reasons why I love the U visa is because it helps you and your entire family. So if I'm a victim of a violent crime, my wife, if she's also undocumented, can get the benefit. My children, if they're under 21 and not married, can also receive U visa status, even if they're not inside the United States today. So once I'm approved, and it can take as long as 5 years nowadays, so once I'm approved, my child will then be able to enter the United States under U visa category. Now, what are the fees to apply for this? Well, it really depends. So I have I met with a potential client just this past week. She has DACA. She's 24 years old. She's had DACA since she was 17 years old. She was a victim of a violent crime. Now, she entered this country illegally, but as a child. She's been in this country now for 21 years, since she was 3 years old. But because she had DACA, she didn't have unlawful presence. She also doesn't have any criminal conduct. So she has nothing to waive. So there is no waiver. There's nothing that makes her ineligible. If you need the waiver that the U visa includes, and the common things is minor criminal conduct, illegal entry, even order of removal. You've already been deported. U visa can waive it. Again, all of these are all negative factors that need to be calculated to whether you will be approved or not. But a U visa can help you. Now, the government charges you $930 for the waiver for each qualifying person. Employment authorization. About 3 weeks ago, the government created something they call bona fide determination. What that means is after you file for your U visa, the government's going to evaluate your application and see, hey, did you fill out all the forms correctly? Do you have a supplement B? Is everything signed? Do you have the documents to show that you are who you say you are? If you do, you will get bona fide determination status, which will allow you to apply for employment authorization sooner rather than later. And what I mean by sooner, if a U visa takes 5 years to approve, that's 5 years. So you might get it in 6 months, you might get it in a year, you might get it in 2 years. But you're not going to have to wait 5 years. So that's a pretty big deal, and it's just a recent change. So what do you need? Well, if you hire an attorney, you're going to need a G-28. That's a notice of entry of appearance that an attorney will fill out. You're going to need the form I-918, which is a petition for U immigrant status. That is for you, the the victim. If you're including your spouse or your child, then you will need to fill out Form I-19 Supplement A. That's for a qualifying family member, known as a derivative. And you're going to need Form I-19 Supplement B. That is the law enforcement certification that needs to be signed by prosecutor, police, or judge. Those are the three most common agencies, and of them, the police is by far the most common agency. However, as I said before, it's any agency with investigatory authority. So, Division of Child Services, they have signed cases like that for us in, well, sometimes in cases of sex abuse, sometimes in cases of child abuse. It's a very sensitive subject because the victim is a child. We don't have access to all the information that we would normally want. So Division of Child and Family Services, and every state has one, can be very helpful in that context. Form I-192, that is the waiver. That's when you're applying for permission to enter as a non-immigrant. And that is when you're saying, hey, listen, I made a mistake. I'm sorry, it's actually Form I-912. That's the waiver. I'm a little dyslexic. I apologize. I get my numbers screwed up. 192 is where you're asking to waive certain fees. So I-912 is where you're saying, U.S. government, I'm ineligible for this reason. For example, I entered the United States illegally, or I have an order of removal, or when I tried to enter the United States, I lied, I gave a fake green card, I was caught and I was deported. So I tried to enter illegally, but I was not successful. I committed fraud, misrepresentation, and I was deported. Those are two things that can make you ineligible, but they can be cured by the waiver. And by the way, that's a real case. That is somebody that we helped. So what other documentations do we need? Well, for every applicant, you're going to need two 2x2 passport style photos. And you can Google Department of State to see an example of what a passport style photo is. But to be honest, you can go to any CVS, Rite Aid, Walgreens, and they know how to take a passport style photo. You're going to need a birth certificate with certified translation for anybody who's applying. You're going to need a valid passport. Now, law only says you need a passport or birth certificate. I recommend you have both. I-94, if you have one, depends on whether you entered legally or not. If you're married, marriage certificate. If you were divorced, divorce decree. Police report or prosecutor's file talking about the investigation and ultimately the conviction for the criminal defendant. Again, do you want to include the entire file? Not always. That's a strategic decision you need to make. It really depends on what the conviction was for. If the conviction is not an obvious qualifying crime, that might not be as helpful. So we really have to look and have to evaluate. But all I need is either the investigation, the charges against the criminal, or the conviction to be containing a qualifying crime or substantially similar to a qualifying crime. Ideally, I have one of the 23. Again, assault, sex abuse, robbery, domestic violence, all of those are examples of qualifying crimes. If this is domestic violence scenario and you have a temporary restraining order or a final restraining order, that is very helpful. Sometimes getting the transcript, particularly when you got the final restraining order and the judge says, yes, you were a victim of a crime. Yes, I believe that that you are in danger. That goes a long way in proving your case. Psychologist evaluation or a therapist, that is when there is more of an emotional harm rather than a physical harm. Because if it's a physical harm, I will get obviously the police report, but I'll also get the medical reports or the hospital documents. Support letters, so that's letters of people that know you and love you and say that you're a good person and you deserve to get this. Taxes, if any, again, this is more to show that you're complying with the rules in this country. And we do a background check for every one of our clients. We want to make sure there's no FBI issues, that there's no I want every document that the government has on you. And if there's something that makes you ineligible, I want to request it in a waiver. Or if there's something I think might be a problem, I might try to fix it before I file for you. Now, that's for the applicant. For the derivative, that's a qualifying family member. If the victim was a child, qualifying family member could be, by child I mean under 21, could be parents and could be siblings of a certain age. If it's an adult, it's usually spouse or children under 21 who are unmarried. So derivative, you're going to need two 2x2 passport style photos. You're going to need birth certificate and passport, support letters if any, taxes if any. Again, it depends if they're a child or not. Now, let's take a look at what these steps are. How do I share? There we go. All right. Now, step one, this is what I show to my clients. This is how we map out the UVisa process for them. So first part is you hire us, or if not, you do it on your own. The beginning is the UVisa investigation. So this is where we order police reports, medical records, psychological reports, any court transcripts. We speak to the prosecutor's office. We want to know that what happened in this case resulted in a conviction, but doesn't have to be a conviction for reasons I said before. But the point is that there's a qualifying crime. There's no point proceeding if we can't at least make an argument that what happened here either is the same as a qualifying crime or similar to a qualifying crime. So assuming we do the UVisa investigation, we ask for all documents related to the incident. That's also where we do a background search. We want all documents regarding you, the immigrant, or your derivatives to make sure that we can get any waiver. So context. Every single consultation, we answer three fundamental questions. One, do you have a path to legal status? One of the 9 is a UVisa that we're talking about today. 2, is there something in your past that can disqualify you? Well, I gave some examples like caught at the border with the fake documents, committed fraud, deported, multiple entries, minor criminal activity. All of those are possible disqualifiers. And 3, can we fix it? UVisa has a waiver process that we can fix most of those issues. So I don't want you to hire our law firm to file a UVisa if we can figure out relatively quickly that we can't help you. So first is UVisa investigation. Make sure that it's a qualifying crime. Make sure that you, the immigrant, will ultimately has a solid argument to receive this benefit. Because if you, the immigrant, the victim, doesn't get it, then your derivatives are not going to receive the benefit either. So number 1 is UVisa investigation. Number 2, once we know that you individually qualify and the crime itself is also a qualifying crime, we then request the supplement B. That is the law enforcement certification. And we don't just ask one location, just the police support department. If they don't respond, we give up. No, we look at every possible agency that could have authority to sign off on this process. Again, normally it's the police, prosecutor's office, or the judge. I have had a few judges do this across the country. It is incredibly rare. It is not common, but it is possible. So what's most often is the police department or the prosecutor's office. But what happens if you reported an incident and the person is not discovered, or they're found, but they're released, whether with bail or with not, and they don't appear in court? So there's an order for their arrest. Well, you can't really go to the judge. You can't really go to the prosecutor's office. You can, but realistically, they're not going to help you. So what does that leave you with is the police department. Now, what happened if they never found the person? Then you can't talk to the prosecutor and you can't talk to the judge. They're not going to sign it, with few exceptions. So you can't force law enforcement to do it. If we don't get the law enforcement certification, the supplement be signed, your case is done. We're not going to move forward. So we'll charge you for a UVisa investigation. Once we have the information necessary, then we'll charge you for to help you with the law enforcement certification. Once we get that, then we work on step 3, which is prepare and mail the UVisa package itself. That's when we prepare all the forms. That's when we get the letters of support. That is where we go over your history and how you were affected. So step 1 is to investigate. Step 2 is to request the law enforcement certification. Once we get that, that's when we prepare and mail your case. So once it's mailed, step 4 is USCIS is going to receive the package and send you a receipt. That receipt has the official date when they accepted the application, and that's your priority date. So you can pretty much put right now it's taking about 5 years. Remember, they only give 10,000 visas a year, and for the past couple of years, a lot more than 10,000 people have been applying, which is why it's been taking longer to get a U visa approval. Step 5, once they receive it, they're going to schedule you for a biometric. That's where they fingerprint you. Step 6 is bona fide determination. That is relatively new. That is where government is going to look at your case and say, hey, did you file everything that you need to file? And does it seem like you might be eligible for this U visa? If the answer is yes, fantastic. They send you bona fide determination, and you can then apply for a work authorization. If they don't give you bona fide determination, it doesn't mean you're not going to be approved. It just means your case is not obvious. They're going to need to spend more time with it, and you're going to have to go through the normal process. Normal process means wait those 4 or 5 years until they look at your case in detail. So you got bona fide determination, then you can apply for work authorization, which you and then get. Then U visa approval. That's where it now takes 5. Again, it's taking 5 years now. It used to take 1 or 2 years. Step 9, now, once you're approved, your derivatives can travel to the United States. So if your spouse is outside the United States, now, if it's just your girlfriend and you're not married, that doesn't qualify. You need to be married before U visa approval. And this is a key difference, and it's new. It used to be you have to be married at time of application. Not anymore. Now it's you have to be married before U visa approval in order to include your spouse in that process. So now you're approved. Your derivatives are getting it. If your derivatives are outside the United States, they're going to get in. You can request that they get interviewed at the U.S. consulate in their country or embassy, and then they come into the United States as U visa derivative. Now, U visa, you get it for 4 years. After 3 years, you can apply for a green card. It's not automatic, but as long as you haven't done anything that would disqualify you, you generally will get it. 5 years after having your green card, you can then apply for U.S. citizenship. Like the green card process, as long as you speak English, you're over 18, pretty much as long as you're a good moral person, you will become a U.S. citizen. It is yours to lose. So you will get it unless you've done something negative that will keep you from doing it. So there you go, folks. That is the U visa process. We just covered what the requirements are. We covered what is the U visa, what are the requirements, what are some of the documents that you need, what are some forms you need to apply, and what are the steps that you need to follow from beginning to end. Okay, so let's see. We have some questions. Robin on YouTube says, I currently have TPS and TPS EAD, so temporary protective status and employment authorization. So does it affect for, I guess it's bona fide determination? I applied for a U visa in September 2020, robbed at gunpoint 3 times, and also robbed. Wow, that's terrible. I am so sorry for what happened to you, Robin. So in context, you applied temporary protective status is just that, temporary. It gives you work authorization. You can apply for travel, but it isn't a path that will ultimately result in a green card or in citizenship. So she said, listen, I have TPS. I was a victim of a qualifying crime, and I applied for U visa. If I get bona fide determination, will that help me? Honestly, it doesn't really matter, because you have employment authorization under TPS. Now, I would continue to renew your TPS up until the moment that you're granted U visa. Once you're granted UVisa status, I would not renew my TPS anymore. But I wouldn't abandon TPS for employment authorization under a bona fide status for a UVisa because you haven't yet been approved. TPS, you're in legal status, period. Bona fide determination for a UVisa just says you likely will be approved, but you haven't yet. I hope that makes sense. And okay, I see Robin gives other examples of what happened. She was harmed. So long story short, Robin, it doesn't matter whether you get employment authorization under TPS or under bona fide determination for UVisa, but until you are approved with UVisa, you should maintain your TPS. Bruce says, I'm Cuban. I wrote you last week for counseling, yet I haven't gotten a reply. Bruce, we tried to get back to everybody. I'm not sure where you wrote or how you did it. Looks like it was on YouTube. Bruce Wayne, huh? Batman. So our phone number is 732-962-1805. My ability to respond on YouTube to questions is limited. However, if you schedule a consultation, you'll talk first to my team, see if we can help you. If we can, you and I will talk directly anywhere in the world. The beauty of Zoom. So that's the easiest way for me to be able to assist you and to help you. Shitesh says, I'm a computer tech. Last year, I support in grocery store and motels as iTech supporters. I report income tax. Am I eligible as an essential worker if passed law in the future? So, Shitesh, thank you for the question. I have no idea. I know that may surprise you, but you're asking me, will I be able to apply for something if the law passes? Well, there really hasn't been, they have not fleshed out what an essential worker is. But let's assume for purpose of conversation that you have to be in here a certain period of time. You must not have a criminal background. You must pay your taxes, and you must be gainfully employed if in something that is considered essentially. So I don't know if a computer tech is considered essential. Maybe it is. But until I know what the law is, I can't possibly tell you. It does sound like you're doing the right things. However, I would not wait until that law passes if it does passes. I would evaluate, give us a call, schedule an appointment. Again, we follow the 953 method. So 9 paths to legal status, 5 things that could disqualify you, 3 ways to fix it. What you're essentially saying is, hey, essential might be a number 10, but we don't know what that number 10 is. That doesn't mean ignore the other 9. So let's take a look to see if you have the other 9. Robin, it was my pleasure. Muhammad asks, when and how can I be informed about BFD determination for a U visa? Well, first of all, you have to have, thank you for your question, Muhammad. You must first have applied for a U visa. What immigration is doing now, what USCIS, that's U.S. Citizen Immigration Services, they are responding to the oldest applicants first. So I have clients that we applied in 2016 and 2017. They're probably about to get a U visa approval anyway. They're getting bona fide determination letters, and we've had 4, 5, 6 already in the past week alone. That will increase. So how can you be informed about it? Well, immigration is going to write to you, or you can ask for your attorney. So what we told our clients is, listen, you got a choice. You can wait for immigration to get back to you, or you can write a letter arguing why you should get bona fide determination and saying, hey, I have all of the following criteria. So if we did not file your U visa case, I would need to evaluate it and see, well, what your status is. Muhammad says you applied in 2018. I have not yet seen a client that we filed in 2018 receive bona fide determination. I imagine it's just a matter of time. What I am seeing are people who applied in 2016 or 2017, but again, they're just working backwards and moving forward. But you can either write to immigration and apply for it, or you can wait and they will communicate with you. Wilmer says, tengo carta individual el otro año. He's writing in Spanish. I have an individual court the coming year. Mi mismo se decidiría ese día si me quedará o me regresará a mi país. con el formulario. Ok, so Wilmer, gracias por su pregunta. En un momento voy a hacer este programa también en español. Por el momento te voy a contestar en inglés. So Wilmer, your question is in Spanish. In a couple of minutes, I'm going to finish this program and I'm going to do the same thing in Spanish. So for now, I'll answer your question in English. So he says, from what I understand, you have an individual hearing in court soon based on an asylum application. Now, there isn't really a question there. If you qualify for a UVisa, that might be a different avenue. Asylum is an avenue. I have no way of establishing whether you have a good case or a bad case at this point. What I can tell you is, in general, in order to succeed in asylum, you need to be, one, afraid of persecution, afraid to come back to your country because of persecution, because either something bad happened to you in the past, or you have a good reason to assume bad things will happen to you in the future. Second, you afraid of whom? The government or a group the government can't control. And three, bad things are going to happen to you by the government or this group for a protected reason. It can't be just any reason. If I walk outside my house and I get robbed, that doesn't mean I'll be able to go somewhere else and have asylum. It needs to be for a protected reason. Not any and all criminal activity is where you were a victim of, are you protected. So protected reason would be race, religion, nationality, political opinion, or a particular social group. It must be one of those five. So you're afraid of, you have a good reason to be afraid of this group or the government, and it's for a protected reason. If you can prove all of that, then you should, and you filed timely, so you filed within the year of when you entered the United States, and you haven't done anything that would disqualify you, like criminal, like any crimes, or having returned to your country without permission. If you haven't done any of those things, then you should be granted asylum. If you want more information, give us a call, schedule an appointment. We'll talk about your case one-on-one. Robin says, is this the same Robin? Forgive me. Yes, it is. So in my case, USCIS does not have a recent robbery report since it happened after applied. So can I write USCIS regarding my recent robbery and request? Okay, so Robin, here's what I understand. You're telling me that you might qualify for a U visa based on more than one crime. Well, immigration is only going to evaluate based on the crime that you applied for. So let's say, for purposes of conversation, you were involved in two different crimes, violent crimes. One resulted in you getting a law enforcement certification and applied, and now you're waiting to get a decision. And while that happens, there's a second incident. So in order for that to be applicable, you would, surviving the police report, it can't hurt, but I don't know that they're going to do much with it. If you want a U visa based on that second incident, you would need to get law enforcement certification for that second incident. So really what we got to do is take a look at your individual case and see, hey, do you have a strong case? Do you not have a strong case? And evaluate there. I can't, bona fide determination just means you provided sufficient information so that immigration could approve your case when it would approve your case. If you didn't do that, the fact that you were provide a police report for a subsequent incident doesn't help you, doesn't change the facts at all. So it might waive things in your favor if the government is like, well, should I approve or should I not? Is this person worth it? They have some criminal issues. But if it's a clean-cut case, all positive, no negative factors, and you have all the requirements, likely you won't need it. But again, if you need more information, feel free to schedule an appointment, and we'll see how we can help you. Then I suddenly, so if they get info in my case, then I suddenly expect. Listen, I can't explain to you whether you're going to get an RFE or not, Robin. There's no real way for me to know because, again, first incident, that's what you're applying for. The fact that you provided information on a second incident, that probably wouldn't generate an RFE on that issue, or at least it shouldn't, because for all intents and purposes, it's irrelevant. Thank you, everyone. Muhammad has another question. One of my friends, I really need to do this show in Spanish also, so this will be the last question. One of my friends got approved U visa on June 2021. Awesome. He had applied in April 2016. Yep, 5 years. I applied in July 2018. When my case could be approved? Well, Mohammed, just applying that logic there, so that's 5 years. If you applied in July 2018, on or about July or August 2023, there's no way to know whether what happened in the past will continue to happen. The delays have been getting bigger every year, but the Biden administration has also discussed increasing UVisa applications to 30,000 instead of 10,000. So I can only tell you, if it took 5 years for your friend, it might take 5 years for you. If the law changes, it could take more or it could take less. That's just an estimate. Thank you very much, everyone. And for those of you that speak Spanish, stay tuned. We're going to do this again in Spanish.